Hey, creative. Are you ready to discuss profits, the money, the ways to make it happen? The Profitable Creative Podcast is for you, the creative, how you define it. Videographers, photographers, entrepreneurs, marketing agencies, you get it. CEO of Core Group and author Christian Brim interviews industry experts, creative entrepreneurs, and professionals alike who strive to be creative and make money at the same time. Sound like you? Tune in now. It's time for profit.
Welcome to another edition of The Profitable Creative, the only place on the interwebs where you will learn how to turn your passion into profit. I am your host, Christian Brim. Special shout out to our one listener in Oxford, Mississippi, home of the Fighting Rebels. Welcome to the CFP. Good luck this weekend. No, they don't play this weekend, do they? Anyway, thanks for listening. Joining me today, Austin Bonderer, not to be confused with James Federer.
Roger Federer.
Roger. I knew the name, but okay. Anyway, I screwed that up. Austin, welcome to the show.
Oh, thanks for having me.
So are you anywhere near Oxford?
I am not. I have practiced in California, and I have offices in California and Fairhope. I'm currently in Fairhope at the moment, Alabama, and then Tampa, Florida.
Beautiful. We were discussing before we started the show that he was from Mississippi, and I was like, well, that's odd because that's our shout out today. So, Austin, you are an intellectual property patent attorney. How long have you been doing this? Give us your CV.
Oh, basically, as soon as I got out of engineering school, I went to go work for the patent office as a patent examiner. So I worked on that side of it. And then basically while working there, went to law school at night and then became a patent attorney on the outside of the patent office.
And so that means you've been doing this for how long?
Since 99. So 26 years, I guess, coming on. Yeah.
Long
more
enough.
than 26 years.
Yeah.
I don't like saying that.
Okay, so this is a little insider ball here. Is the USPTO similar to other federal bureaucracies where the examiner, as you were doing, has a lot of discretion in how they apply the law? I ask that coming from the IRS side of things, and when you deal with the IRS, it really is much more subjective than you would expect, or maybe you'd like it to be.
So the first thing I tell clients is, while there's one U.S. patent office, there's really like 8,500 of them because each patent examiner is their own little patent office. And once you become a primary patent examiner, which means you have X number of years of experience, then you go through this thing called the program, and they tear apart your work for a year. And if you prove yourself, then you almost get no one can overrule you except the trial board, not even your supervisor generally.
And so it's kind of like just the way they apply the law as the way they understand it, and so there's more nuance than or not.
Right. And one of our biggest arguments between them is you can't patent something that's, while it's not the exact same as something that's found in the prior art, it can't be considered obvious. So yes, you and
obvious
I
to
right
who?
now, you and I can have a discussion about what's obvious, and chances are we would not agree. So
right, yeah. You're living in a rock. What do you mean obvious? Okay, so you use the word art there, and that's interesting to me. Is that a legal term that is used?
Yes, but everyone's familiar with it. When you hear the term state of the art, it's the same thing. It's all the knowledge and information that's out there. So when you file a patent application, anything that existed before that filing date is considered prior art.
Okay. Interesting that they use that term. Okay. So let me ask you this. As far as my understanding is that all patent attorneys have some type of technical background. You have engineering. Is that where is that applied? That requirement, like to be able to be certified to work with the patent office, or like is that a
Exactly.
explain it to me?
So basically, to be an attorney, you have to pass a state bar. In order to be a patent attorney, you have to have passed a state bar, and then you have to have passed or be admitted to the patent bar. Most people have to pass the patent bar to be admitted. There is a kind of a loophole, is that if you work at the patent office for more than 5 years, if you could go out to the outside, they just admit you because they believe that you're qualified at this point in time to, pass that test.
Okay. So is there a similar requirement for other intellectual property?
No, it's the only one that requires that. So any attorney can do trademarks, any attorney can do copyrights. So we call those the softer IPs. Copyrights tend to generally be worked with when it comes to entertainment lawyers, because they're dealing with music, books, writings, and this kind of stuff. I'm a little familiar with that, but it's very easy to file for copyright. You just kind of register it with the Library of Congress. People, it's fairly easy. People are able to do it themselves much easier than they would be able to file a patent. A trademark falls in between there. A lot of patent attorneys do trademarks because it is the Patent and Trademark Office, but there are also a lot of attorneys out there who do not have a technical background, who are extremely qualified in doing trademark law and obtaining registration for your trademarks with the trademark office. Now, that is one misconception I have to explain a lot, is that as soon as you sell something, service, or a product, and it has a name to it, you have a trademark. The government doesn't give you a trademark. What happens is you want to get it registered because of all the legal benefits that you get when a trademark is registered, federally registered with the trademark office.
And some of those benefits would be,
well, it's so you don't have the so once you have a trademark, you start to be protected under common law. And one of the things that we suggest is that people use that little TM that you may have seen in usage. If you don't have a registration but you're claiming a trademark, that puts everyone on notice that you are actually claiming a trademark. But with common law, you have things like geographic constraints, like say you were only in it's a little different with the internet now, but say you have a thriving burger chain on the West Coast, maybe In-N-Out would be an example or something.
In-N-Out Burger. That was the first thing that came to my mind.
Exactly. So I miss it much. So I haven't had one in a while. So one of the things with that is that, if someone opened up a restaurant in, say, New York, and this is when they were, we're talking 20 years ago, right?
Right.
In New York, someone opened up a
ancient
restaurant.
days.
I'm sorry. Yeah,
Ancient
before
days.
the internet, right?
Yes.
So if they opened up one in New York City, In-N-Out in California, if it didn't have a federal registration, it was generally localized, and only people knew it in that general geographic area, there was no likelihood of confusion with the company that started in New York. But the people in New York started gaining rights, so they can't just also force them out of business if they grow. So you end up having to get stuck with them. So once you get a federal registration, that would prevent that from happening. So even if you're just, like a small regional company and you get a federal registration, you prevent anyone from using that name or that logo or whatever across the entire United States.
So, as a practical matter, it's best to be proactive in protecting your intellectual property. I mean, obviously, there's a cost benefit. What and I'm assuming obtaining a patent is much more expensive than getting a trademark registered. What can someone expect to spend? And assuming that there's nobody else out there contesting what you're doing. So in other words, you've got a patent that's not a Dyson vacuum cleaner, and you're not trying to use Dyson and getting into protesting something that's already there. How much are we talking about budgeting?
I mean, a good range, you're generally talking about 10 to 15 would be a good estimate, but that can be spread out over like 3 to 4 years. So it's not all up front. So basically what
For a
happens
patent or a
for the
trademark?
patent, because the
Okay.
trademark, if there's no issue going through, generally you could see something within a year, and it sometimes, you're generally looking at, and if it's only one class, and I'll explain that in a second, you're generally looking at, possibly, $1,500 to $2,000 to 2,500, somewhere in that area, if there's no hiccups. And what we mean by class is kind of like, say you had Acme Oil Company and Acme Seafood Company. You can actually have same names, in use, but they're not in the same class because people aren't generally likely to confuse an oil company with a seafood company. I mean, I don't know. Maybe they would with all the oil spills, but you know what I'm saying. Uh, that's one way they kind of delineate the items is that you are registered generally within a class, and the more
So the
classes that
class would be more. I'm sorry. So to clarify, the class is more like akin to an industry. So like Delta Airlines versus Delta Faucets.
exactly perfect. Yes, you can definitely have
Okay.
that. In fact, one of the biggest things forever was Nissan was trying to sue. If you ever went, I don't know if they still have it, but if you went Nissan.com in the United States, it'd pull up a company and not the car company.
Yes, because it was like Nissan USA
Yeah,
.com
that's
for a
what they had to end
long
up coming
time.
up with. Yeah.
Yeah. Okay, so that's interesting. So let's go pull it back another 10,000 feet. We've only talked about federal for our purposes. Are there similar legal mechanisms in other countries?
Totally. I mean, so it's actually kind of nice that generally we can file. So if we file for a trademark in the United States, if we file within 6 months, we can file to register under the Madrid Protocol in a bunch of different member states. Brazil, Europe, Australia, these kind of things, all over the place. You have to pay, but you generally go
Right.
ahead and get your foot in the door, and you're trying to secure the naming rights in those industries. Um, a lot of things with trademarks. You mentioned the airline. One of my favorite things to tell people is American Airlines does not have a registered trademark.
Interesting.
Yes. So if you look at them, because one of the things you can't register as a trademark, I mean, granted, you can't open up an airline and call it American Airlines, but you can't prevent Delta from saying they are an American airline. Because
Fair. Okay.
so when you trademark
Because they
something,
are.
right, when you trademark something, you generally take those words out of the lexicon so others can't use them
Right.
for likelihood of confusion. So American Airlines is very descriptive of what it is. So you will see they never have an R with a circle around them. I can only assume is because it's so descriptive that they can't get it. Now they may be on the second, but you can't open up an airline that says American Airlines either. You see what I'm saying? They have some rights in the name because at the end of the day, trademarks is not for the owner, it's for the public. It's for the protection of the public. And now I don't know if you remember. Do you ever remember watching? Was it Coming to America?
Oh yeah.
Yeah, and
Great movie. Eddie Murphy.
McDowell's was the family
McDowell's.
restaurant, and
Yes.
McDonald's kept coming after them. It's because
Right.
people are likely to be confused. They're driving down the street, they see something that looks like golden arches, they're going to run in, and boom, they may have been hoodwinked into buying something they didn't think they were buying. So we use trademarks as an identification of source of goods. So we in commerce can make split decisions about quality and things that we want to spend money on.
Hey, listeners, are you ready to turn your passion into profit? Then grab a copy of Profit First for Creatives. Click the link in the show notes to purchase a copy. And if you're not ready to make that full commitment, you can download a free copy of the first chapter. Check it out right now. Okay, so you answered the international question. Let's zoom down in. Is there any mechanism at the state levels or state levels in America where you have to do something beyond the federal?
Right. So if you have the federal, you're protected. You
Okay.
can file for state trademarks. It's not something that a lot of people do. So understand, to get a federal registration, you have to have interstate commerce.
Okay.
Yeah, if you were just totally in California, even though it's, you would say 25% of the commerce or 20% of the commerce of the United States, you still can't get a registered trademark, federally registered. Now, you can apply for a California based trademark that is registered in California. Generally, you register your company name and that's protected, but you can also make it a step further and try to get a trademark registration through California. That will not give you the R with the circle at that point.
Okay, so you've got a gray beard like I do, so you have lots of experience. Where do you see across any intellectual property? Where do people? Uh, how has this worked out poorly for them when they didn't protect their intellectual property? Like, what? Give us some examples of how that went bad.
Okay, so had some people come to my office one time and they were in a panic. They had this product that they made. They went on Shark Tank, did pretty well, but the problem was that their supplier in China saw what they were doing and saw how popular they were doing and basically gave the supplier a list of all their like customers, like these big stores. So what the
Mm,
supplier did was just say, why don't we just contact those stores ourselves? And they end up
sell
losing.
it and
Yes,
take that profit.
yes. And they didn't have
And
access
so
to that.
they
They were out.
the, they were done. There was nothing you could do at that point.
I mean, they may have been. I mean, if they did their contracts properly, if they said, "Hey, we're manufacturing with you. You cannot contact our customers. You can't do all this stuff," they might have been able to sue under contract law. But then the question is, how do you enforce that overseas? Where you're enforcing that in China, you're
Yeah.
enforcing that here. You would have to draft your contracts properly. And I highly suggest if you're manufacturing products, you do have an attorney look at those contracts. But a lot of times, those manufacturers aren't messing with you unless you sign their contracts, because unless you are coming in with a large, amount of money and orders, they're like, this is our normal stuff. We're not going to pay an attorney to review every single person who comes in to build something. So you're kind of stuck. Now, a patent might be an easier way of doing that if you don't see yourself right off the bat, supplying them with a bunch of orders, because then they're willing to bend what they normally do for you.
So okay, let's carry this thought exercise a little further.
Okay.
If you had a patent and you had an overseas manufacturer, and they're violating your patent, but they're doing it in another country, but they're still trying to sell that product into the United States, does that patent protect them? I mean, would you be able to say no? You can't sell this thing into the United States, and how in the hell do you enforce that?
So so all patents are local. So basically, a U.S. patent protects you in the United States, doesn't protect you in the rest of the world. So in that instance, you have a U.S. patent, your manufacturer decides to sell all over the world. You can't stop them from doing that. But what you can do is, sue them here in the United States under your patent if they violate your claims. Hopefully, you have some kind of contractual, thing that you did with them. You could sue them under that. It's actually easier to sue under contract than as patents. Patents can be very difficult to sue under. Um, and then the other thing is you can get orders through the FTC or, with customs, and you can basically get things
Hmm.
stopped at the ports. If infringing items are coming over and they know to look out for them, they will seize them at the port and say that, these are understood to be infringing products.
Does that actually happen? That
Yeah.
sounds complicated.
No, I mean, it's
Okay.
barely happening. I mean, it's a lot easier when it's a bunch of Louis Vuitton bags. and that's a trademark
Yeah.
infringement, a source of good, knockoffs, and that's trademark law. But the same principle applies. If it's violating, intellectual property rights of people, law, patent holders or property holders, the government will try and stop it. But the sheer amount of things that come across in the containers, it is difficult.
Yeah, and I'm just thinking about what I've seen in the marketplace, where you have a successful product and there's always knockoffs, and they may be, US knockoffs. They don't necessarily have to be overseas knockoffs. And I guess my question is that would the proper legal planning, including patent application, help those businesses protect or not in practical terms?
Right. Well, one of the practical terms I tell all my clients is that when you come out with a product and you have a patented product and it looks like it's doing well, you should be working on your own knockoff. You should be trying to catch both spaces. And
That's
then
interesting.
hopefully you box everyone out. But there are people who are willing to pay the high price, there's people willing to pay the low price. You might as well capture all of it.
That's a brilliant idea.
Yeah.
That is brilliant.
Yeah.
Okay.
But
So,
yes,
go ahead.
you just use the law. You sue them. Amazon's very responsive to, hey, here's my patent. They actually have programs in place where you contest. You say, hey, this is violating my patent, and then you basically challenge them to an Amazon program where they have a qualified patent attorney look at both sides. There's very strict rules, and if they find that's infringing, they take it off. And you're able to do that. So at least it's a lot easier to get something thrown off the biggest seller in the United States than it is go through the courts.
Yeah, I was thinking, I read somewhere recently Amazon was having trouble because some famous author, and I don't remember who it was, who had an upcoming book, somebody came in and started selling the book before it had been published. Obviously, it wasn't the same book, but it had slipped through Amazon's guards, and they were like, "Oh, well, we'll do better next time," but the damage is done.
Hey creatives, Delana Ely here. I had a question for you. If you could pay yourself more, why aren't you doing it? For real. S Corp is an option for you, the creative entrepreneur, to move your business to the next level, to pay yourself more, and to cut your tax savings down. Yeah, less money to the IRS. We want that, right? So why haven't you done it yet? What's going on? The reality is you probably have 50,000 questions in your brain. You don't know which way is up and down, and you're still too busy to do all those things, plus also create, right? Well, the good thing for you is that Core Group is actually the place to be to get that S Corp election rolling. Yeah, we have an assessment. Let's see if you qualify. Come chat with me. Core Group, turning passion into profit.
I am curious. So, like URLs, IP addresses, those aren't subject to patent or trademark law, correct? Or trademark.
Kind of. Okay. There wasn't, I don't know if you remember at the time, there was this thing called cyber squatting. And basically, when the internet first started, the smart people were like, I'm going to register McDonald's.com before McDonald's even knows about the internet. And then when they want to use it, they're going to pay me a lot of money. So eventually the government got upset with this and passed the Cyber Squatting Act. I think it was in 98 or 97. I'm not exactly sure. Long time ago. But basically the premise is, if you have a trade, and don't quote me on this, it's been so long since I know the elements, but it's basically like if you were sitting on someone's trademarked name and you were not selling the product and you were trying to make money off of it and this kind of stuff, they could cause the international body to seize that website from you.
Yeah, because the I don't remember what organization regulates that, but it is not domiciled.
I remember that one.
Yes. It's not domiciled in the United States, because I know when I published my book, I went and looked and somebody had profitfirstforcreatives.com already registered. And they were non-responsive in trying to buy it. So I just replaced FOR with the number 4 and went with it because it wasn't worth the hassle and, blah, blah, blah. But I'm just wondering, do you run into any of that where people are trying to enforce that and get a domain for a trademark that they own?
That is not something I've worked with. I'm sure there are trademarks
Okay.
attorneys that do it. I think most people, unless they're a major corporation, just kind of do what you did and like just find a workaround because you're like, I'm
Yeah.
not going to reward this person. And then you can set up a tickler or a tracker, and hey, when this thing comes on the market, it comes free. The person doesn't, then you can try and grab it. But that's. I'm sure there are people out there who use that law. I haven't heard too much about it in my practice.
Yeah, it's kind of like I tell my attorney, who's not an IP lawyer. He's just a general counsel kind of lawyer. But it's and he kind of laments the state of the legal profession in the United States. That like a lot of lawyers, especially like ones he hires as employees, it's like there's the law, and then there's the application and the economics of law. Like, yeah, you may be right, but it doesn't make sense for you to go down that legal path because of the money involved and the time involved. Do you encounter that, I assume?
Well, yes. I mean, we do that in trademark as well. So when you file for a trademark, it goes through the examining process. And what happens is the examiner's like, okay, we're okay with this. Then it gets sent out for what's called an opposition period. And during that time, someone from the public can file an opposition. If they have a trademark or a right or something that's very similar or exactly like your name, they say, we have the superior right. You cannot issue this. And then you can go to basically a trial with subpoenas and discovery and all this stuff. And, a lot of people are just going to be like, we're not married to the name at this point. We just started. We can rebrand cheaper than that's why I tell them. I'm like, you're going to spend more money on this. When you start out, cash is king. Use that
Right.
money. If you really want to spend that money, spend it on advertising your new idea or your new name. So, one of the things I tell my clients is, say that they're like, hey, we're about to launch. We're going to launch in about, 8 months, 9 months. I'm like, pick 3 names. And let's file intent to use on those to see which ones get through. Hopefully all 3 do, and then you can pick your favorite. But if 1 happens to fall or 2 happens to fall, then you at least might have 1 that you can launch with.
Okay, I'm gonna branch out in this the area of copyright, and if you don't feel qualified to answer, you don't have to. But nowadays, there's obviously AI and a lot of stuff that is out there on the internet is stolen. Um, what's the practical need for someone to copyright, say, the copy on their website? Regardless of their industry, regardless of their business, does it make sense to get a copyright on your content?
Well, technically, you already have a copyright on your content. So the way it works in the United States, you don't have to file for copyright for every time you write a new article. If you write an article, that's your copyright. That's your written word. They can't copy verbatim, but you can't protect the information therein. And this is where the AI goes back and forth is, yes, this is an automated scraping of the internet, repackaging it and putting it out there. This isn't like an amalgam site, like you remember, the Drudge reports and this kind of stuff people were upset with because they were literally making money by just directing people to sites. They were like, we curate what you think you might be interested in, but you go to the site, we get a cut, but you've made all the content.
Right.
This is a little different. This is, I mean, if you really think about it, some person does the same thing. Half the time they read articles and they spit it back out and they do all, this is how they come up with their own ideas, or, they're, you know, some people say there's very few original ideas out there. It's just regurgitation and repackaging of things they've already heard.
That's fair. So explain. I've been told there's a certain term called fair use that allows you to use some content, even completely ripped off, like video or audio. Like I'm gonna take this copyrighted stuff and I'm gonna use it under fair use, and I'm free and clear. So explain that concept to us.
Well, I mean, I remember the biggest. I was a kid at the time when they went to the Supreme Court, but the ones who pushed this was Two Live Crew versus Roy Orbison. I don't know if you remember that one.
I did not know that. I do remember both those artists, but I did not know that they were involved.
Yes, it was the one. It was Pretty Woman. They sampled it, and they basically did a big kind of remake of it. And Roy Orbison was not happy about it because it was very crude and lewd and all this other kind of stuff.
Completely different genres.
Totally different. And, I have to say as a kid, I was like, like this. But that being said, the Supreme Court basically sided with Two Live Crew saying, we can't stifle art. So you're able to use a certain amount of direct copyright of items, as fair use. So I think with music and sampling, you're certain amount of bars or time or something like that you can use that's considered fair use. But I also think what they've ended up doing is that there's some kind of association. It's kind of like antitrust laws. They have some kind of union representing all the songwriters. They get money if they get sampled. They get money if they get if they were like an artist on the song, they get money. If they were the writer, they get money. It all depends on that breakdown. But I think that's kind of how they use it. But fair use means you're allowed to pull certain amount of copyrighted material as long as it's not the whole substance of what art you're producing or what you're writing.
Yeah, I think the example was I was talking to a movie producer, and I think it was a documentary that he had written, and part of it was filmed inside the car, and on the radio some Beatles song came on or something, and like that was okay, that was fair use. Had he just played the Beatles White Album on his documentary in its entirety, that's not. Is that a gross example?
Well, I mean, no, that's kind of but it's got to be limited. Like you couldn't just put an hour worth of interview and some music's on in the background. There's a limited amount of time that you can use. An interesting story I was reading about is that there was this they call them public auditors. They go out and they just record police all the time, and this one police officer knew that all the algorithms were going to prevent certain songs from being uploaded to the internet. So he would blare like Britney Spears or Taylor Swift or some of these artists where YouTube is on it like this. Like they are just on top of it, getting it off, removing it, content, because they have been threatened to be sued by these large artists. So they were using that to basically prevent these items from being uploaded.
Oh, that's fascinating. That's brilliant. That's brilliant.
Using the technology filters to keep yourself offline. Yeah.
Absolutely. Okay, so a couple of final questions. If I'm a business owner, what do I need to be on the lookout for to proactively protect myself, either from being sued or from my company being damaged when it comes to intellectual property? Like, what's the most common thing that you see where people like, I wish you'd talked to me 6 months ago or a year ago, we could have kept this from being a problem?
Well, I mean, a lot of times what you're going to get is a cease and desist. And that's kind of, you might lose some money by, stopping what you're doing or this or that. Generally, we try to do, if you want to come up with a new name for a product or business, talk to an attorney, let's do a trademark search, see if you can eventually get that registered. federally. When it comes to patents, we can do, freedom to operate searches to see if there's something out there. But understand, no search is 100%. It's an art, not a science. People are out there doing it. The search that they do on Tuesday with the results would be different than if they did it on a Wednesday. It's just the nature of the business. You hope that the core of what they find is very similar, but you might pick something different in there because, when you're dealing with inventions or products, there's a lot of parts, and you might be more focused on this part on the left than you are on the right. It might change day to day. That's why these searches are never the same. Two, we're stuck with time and scope. We're not going to search all over the world. I mean, we can, but that's going to cost hundreds of thousands of dollars. So I tell people it's kind of like an insurance policy. We do the search, we hedge the risk that you're not going to be in trouble later. Two, if you show the government that if you ever got sued and you showed them that, hey, we did a prior art search, we have an attorney look at it, he told us we were good, at least that might not stop a finding of infringement, but generally it will stop a finding of willful infringement, which is 3 times the damages. So they take the damages, multiply them by 3. They punish you greatly for that. So, the one thing I tell, if you think for patents at least, because the biggest question I get is, how do I know something's patentable? I'm like, we don't know because of prior art and whatnot. But I always say, if you solved a problem, like if you had something stump you and you were kind of thinking and boom, you came up with a clever way around it, that might be something that's patentable. That might be something that you can use to obtain a patent, which I also say is kind of a form of insurance because it ensures, it allows you to explore the marketability of this product, hopefully without competitors jumping in. But there's no guarantee.
And to clarify, patents only apply, maybe, this is my question. Patents only apply to physical objects like software it does not apply to, or does it?
It can apply to methods of manufacturing and this kind of stuff, but it is ever since the Alice decision, it cannot.
Meaning I can't get a patent on my software.
Right. But certain softwares you can. So the way I tell people to think about it is like, look, if, I always, movies, Rain Man, if Rain Man could do it in his head, you can't get a patent on it. So basically, if Rain Man can take some information in, process it with an algorithm, or compare it to the knowledge in his head and spit out an output, you can't get a patent on that. But there are certain softwares that can, because it's something that Rain Man can't do. If you can make the internet run better, if you can make transactions more secure, if you can increase the security of communications, that's some kind of item that can. But I got to tell you that the patent office is all over the place on this. It's called patent eligibility. They have this test. It's very difficult, very hard to understand, and it's very. I tell people it's almost not worth it. Now, you might have the most wonderful software in the world. Maybe it will be worth it at that point. But even when we were getting patents for software, it took 5 years plus. So,
and by then,
the way software
the problems changed. Yeah.
We'd hear from our clients, thank you so much. You're doing a great job, but we stopped doing that 3 years ago because it's easy. It's not like you got to change a product line. It's not like you got to remachine everything. You just hit a couple buttons, hit enter, and boom, the whole thing's changed.
Does copyright law apply to software code?
Yes, but that's exact. It's just the code, like exact code. You can't protect the functionality, but someone can't come in and copy and paste what you have and throw it up. So there was this old thing. I don't know if it was true, but the joke is that Microsoft would always put, their phenoms, their 14-year-old employees or whatever they were, on all these different little software projects, and they have to write a little bit of code because the way the copyright law works, because of the mouse, it's 90 years plus the life of the inventor or creator.
Oh. Okay.
So what their hope was is these young kids would live forever. So then it was 90 years and this kind of stuff. So that was always kind of the, I don't know if it was true, but that was that was a myth at the time, or what was being said.
Austin, this has been very informative. If our listeners want to reach out to Austin Bonderer, not Roger Federer, the tennis player, is that
That's
correct?
right.
Okay, I got that right. Now that I made that connection, how do they find you?
They just look up bondererpatents.com or just put in Bonderer and patent, and you will find me because I'm the only guy out there with that name doing patents.
Perfect. Listeners will have those links in the show notes. If you've liked what you've heard, please rate the podcast, share the podcast, subscribe. That's the third thing. Subscribe to the podcast. If you want to listen to something different, you can shoot us a message. Tell us what you'd like to hear, and I'll replace Austin. Until then, ta-ta for now.
Thank you.